In reviewing a revocable living trust, there are some notable distinctions between a trust that's created by a couple and a trust that's created by an individual. So for purposes of these videos, I am actually going to divide out those two types of trusts separately. So for purposes of this video, if you have a joint revocable living trust with a partner or a spouse, then proceed through here. If you separately have a revocable living trust that is just created by you as an individual, please look at the other video for a little bit more clear context. Now, in reviewing a revocable trust, the important thing to keep in mind is that the document is lengthy and it is dense, but the function of a trust is that it should last the rest of your life. And so, in the context of how our lives continue unfolding, we may acquire new assets. The laws and the tax rules surrounding trusts might change. The circumstances of our beneficiaries will almost certainly change over time. Our wishes simply are going to change. So, when reviewing a revocable living trust, the important thing to keep in mind is that much of the trust language and much of its depth, it's designed to be accommodating. It's designed to be flexible, that as these different changes happen over that period of time, the trust can be adjusted or it can respond to those changes without needing to go into the probate court to be modified. So when we look at trusts, we're going to see a long document. But what you want to keep in mind is that generally speaking, and your situation might be slightly different, but generally speaking, it's only going to be about the first third of the trust length that is going to apply to you. Typically, this is going to be everything through the article that's going to be called our beneficiaries trust or our descendants trust. And then occasionally it might even go through the final article that we're seeing here, Article 10, which is called remote contingent distribution, depending on the decisions that you make. So when you open your trust and you start reading through it, always remember that the specifics of your people and your plan are generally only about the first third to the first half of the length. The remainder of the document, which you'll see some highlighting, but you'll see a lot less than in the first part of it. The remainder of the document is really going to be encompassing legal language and a lot of contingency language. So, in reviewing a trust, the very first thing to know is that when you create a trust for the first time, you can name it anything you choose. Now, if you already have a trust coming in, you're going to continue using the name of that original trust. But when you're creating one for the first time, you can name it anything you want. And generally speaking, we recommend that. So the legal name of a trust is what's underlined here. It is the trust, dated ultimately the date that you're going to sign. So the date that you might be reviewing on a drafted trust, that's likely to change to the actual day that we're going to sign the document. In between the words the and trust, that is where you have the control to name this whatever you might want. Now, no names are taken. Trusts are private entities, so there's no particular registrations that would cause people to reserve or take a name for themselves. And trusts are tied to you as an individual. They're tied to your social security number. We're going to cover that in just a second. So your trust is unique to you. So you can name it anything that you like. We generally recommend that you name it something other than your name because trusts as private legal entities can grant us an additional level of legal privacy that we don't currently have. So we'll encourage you, come up with a name if you would like. It can't be too long, so come up with something that you think is reasonable. You can send that over to us, and then we can let you know if you may need to shorten it or structure it in some different way to avoid any type of confusion. Now, I will go through the trust context directly, but there will be a table of contents that you can peruse. There will be a number of pieces highlighted in it. So obviously we recommend review, skim through the sections that are highlighted, But if there's anything beyond that that you'd like to read, you're more than welcome to. And at a minimum, just making sure that the people that are listed in the document, any particular data like the spelling of names and dates, and of course the plan for the inheritance, you absolutely want to make sure that all of that is accurate throughout. So proceeding into the trust substance. At the beginning of the trust, it's simply going to be identifying this is our trust. So the creators, the owners essentially of a trust, are called grantors. So you are the owner, and you will always be the owners of your trust. The managers of a trust, the people responsible for carrying it out, those are called trustees. Now, typically speaking, when clients come in, they're going to be the trustees of their trust initially. And if one of them couldn't serve for any reason, the other is going to continue forward in that role. At some point, both of you will not be able to serve. And so then we're going to have backup or successor trustees that are going to be listed a little bit further, usually in Article 3 of the trust. So at the outset, the trust is simply saying here, we are creating this trust. This is our trust. We are the grantors. We are also initially the trustees. And in 101, this is the trust. This is the name of the trust, and this is the date of the trust for all purposes. Section 102, this is providing our ability to use a document that we're going to end up signing at the signing meeting. The trust is a long and fairly dense document. And so not only do other people not want to read your trust for the most part, you don't want to have to go out and make a number of copies to be able to provide banks and insurance companies and the like. So one of the documents that you will sign in the signing meeting is called a certification of trust. And there's actually another document that's called a trustee affidavit. These are each one-page summaries of the legal structure and substance of the trust for third parties to be able to understand how to properly manage and set up any assets for you. So that's what 102 is referencing. Third parties can rely on these other instruments we'll provide you. In section 103, this is essentially providing that the legal nature of property that we own now doesn't change once we move it into this trust. So effectively, if I own a house right now in my name, and I then move my house into my trust, well, I still own that house because I own the trust. So for the remainder of our lifetimes, once we move assets in, we still have total control over them. They're ours. We can use them. We can get rid of them. We can put things in and take things out without any tax consequences, which I'll cover with you in just a moment. A couple specifics about Section 103. The first question we often receive is, why does the trust say that I'm putting $10 in it? So one of the kind of minute legal rules about trusts is that when we create the trust, we have to put something in it immediately. So instead of trying to itemize what all of your assets are that are going into this, and the fact that your assets are going to change over time, instead what we're going to do here is just say that you gave the trust $10. You don't have to do anything further with this. You don't have to give us 10 more dollars. This is just to meet a little legal formality to make sure the trust is valid. Additionally, you're going to see some explanations of different types of property, such as community property, separate property, and joint property. As I said, the legal nature of property, once we move it into the trust, it doesn't change. So if I have separate inheritance that I received from my parents, and I choose to put that inheritance into our joint trust, my inheritance is still mine. I still have full legal rights to it. I still own it. And should we get a divorce, as an example, I will receive that inheritance back as my sole and separate property. It doesn't lose its character because I put it into our joint trust. Now, separate and joint property are the two types of property that everybody's going to have in Colorado. Community property, there are currently 7 states in the United States that operate on something called community property laws. It's a different legal structure for how we classify ownership of assets between married parties. Colorado is not a community property state, and so there won't be any community property issues here. But if you happen to have assets in a community property state, for example, maybe I own a house in Texas, or maybe I own a rental property in California. Those states are community property. And so essentially what this is saying is those assets will be governed by those community property laws once they're moved into the trust, regardless of the fact that our trust is potentially in Colorado. In 104, when we create a trust, we own it. And so, as the owners of the trust, you have absolute and total authority over it. As needed, you can change the trust. You can put things in, you can take things out, you can get rid of the trust. So section 1.04 is essentially saying, what are all the rights that we are keeping as the owners of this trust once we have created it? Only the owners of a trust can change it. The beneficiaries, the trustees, etc. Once this trust vests, meaning that we have passed away, it becomes what we call irrevocable. And at that point, there are substantial limitations placed on the ability to make any changes to it. So essentially, the final version of this trust that's in effect by the time we both have passed away, that is the final version, and they will take it and move it forward from there. 105, you're going to see a section called Grantor Trust Status. This is fairly short, but what it's identifying is that for all purposes related to finances, to taxes, to income, etc., our trust is always going to be tied to our personal Social Security numbers, either of them. The function of the trust for the rest of our lives is it's basically a pass-through. Any income, dividends, capital gains, etc., that might come into the trust, it's going to flow through to our personal tax return like it always did before until both of us are gone. And then at that point, the trust is going to change once it becomes irrevocable. Then the trust will have its own tax identification number and it's going to essentially take over responsibility for our taxes after we're gone. Article 2 will have the same family information mirrored from your will. So make sure that names are correct, make sure the dates are correct. And again, there may be references in here in terms of a blended family that certain children are only the biological or adopted children of one of us. But for purposes of creating the legal relationship for inheritance, we're going to be identifying them as the children of both of us. This language, if it is in your trust, it doesn't identify that you're adopting the person. It doesn't extend any legal rights or obligations beyond simply saying, I'm creating the relationship for purposes of inheritance. In what's typically Article 3, we're going to identify trustees, who is essentially going to step in after us, and then what are any number of contingencies related to the trustee role. So there's only typically going to be two sections highlighted here. The first is going to be trustee succession while we're alive, and the second is going to be trustee succession after we've passed away. So in these, generally speaking, unless there's a reason not to list each other, we're usually going to list each other first. And then if both of us can't serve for any reason, we're going to have an identical list of backup trustees that step in again if I'm alive but can't make decisions, or ultimately once I've passed away. Now, the remainder of Article 3 is going to be our first batch of legal and contingency language. You are welcome to review every line of this. I will tell you for the most part, it's just very simple and straightforward because we're trying to provide some solutions to situations that could come up in the future to make things easier for the trustees. So, resignation of a trustee. What is the process? If a trustee doesn't want to serve any longer or can't serve any longer, what is their process to step down from that role? When we get to the end of the list of trustees, unfilled vacancy, it is technically possible we might run out of trustees. So it's always important for us to have a lot of backups. But if for any reason you don't have enough backups or you exhaust all of your backups, please know that there is a process by which a new trustee can be appointed after the list is expired. Appointment of a co-trustee. When a trustee is serving, they may not want to manage everything on their own. They may not just have the time or the capacity to manage everything, and that's okay. When a trustee is serving, they are allowed to appoint other people or even a company as a co-trustee to help them administer this trust. That appointment will run for the remainder of time that that particular person is serving as trustee, the one who originally made the appointment. If they step down, if they pass away, etc., then that co-trustee also effectively has stepped down, is gone too. Corporate fiduciaries. So one of the options you will always have is that a professional trustee can step in to manage the trust instead of people, including friends or family. So this is simply providing here if a corporate professional trustee steps in, it has to be an actual company, somebody that is an operation. It needs to be somebody that's not a family member, not a child of a beneficiary, etc. Incapacity of a trustee, just like how you can't make decisions if you have become incapacitated, we also can't allow trustees to continue making decisions if they have become incapacitated. So you are the first trustee, most likely. So in that situation, you'll manage until you can't. And then if you become incapacitated, the next trustees will step in. And if they became incapacitated, we keep going down the line. This is simply identifying here, essentially, how do we determine that a trustee has become incapacitated? Appointment of a special trustee. Now, this is very rarely used. But there might be circumstances where we need to bring in a special third-party trustee to do something. You know, the examples are pretty limited, but let's say there is a commercial property that I own in California, and I'm here in Texas. Well, my trustees are going to be here. They're not going to want to manage a commercial property that's out in California. So maybe we appoint a special trustee to be out there managing that specific asset at all times. And then the other trustee will manage everything here. Other reasons, there can actually be investigations that are conducted. Let's say there's a concern about financial mismanagement. Maybe there's a special trustee that gets appointed to audit the books and records and then the taxes of the trust. Again, it's pretty rare that this might come up, but it is there should we ever need it. Documenting change of a trustee status, very simply, we can't do things verbally. So if a trustee wanted to resign, as an example, they have to actually write down and sign their resignation and then deliver that to the people who need notice of that. Notice of removal and appointment. So this is unlikely to be used in most instances, but as an example, if I have created a trust, I might get to a point that I don't want to manage it anymore. Maybe I'm 90 years old and I'm going to put in my family members to manage it for me. I, as the owner of the trust, still have powers over it, including to remove the trustee. So if there is ever a removal power that's activated, that's utilized, this is just providing how that removal notice is provided to the trustee. And then prohibited trustees at the end. One of the fairly lengthy and very technical sections of your trust. It's a little bit later and it's concerning what we call a special needs trust. There are a lot of rules about special needs trusts, but they serve a valuable purpose. And so if a person is a beneficiary of a special needs trust, one of those rules is that they cannot ever serve as trustee. So this is just reiterating that here to make sure that that rule gets followed. Now, two sections that are fairly straightforward, and they're going to deal with you specifically and in somewhat of a chronological order. We're going to have administration of the trust during incapacity, followed by administration of the trust after death. So during incapacity, while we are alive and we're healthy and happy, we run our lives, we manage our assets, we do whatever we want. Again, we might get to the point that we can't make our own decisions, and that's okay. But this is our trust. So, Section 4.01, very importantly, just because I'm incapacitated doesn't mean that this is no longer my money and my property. For the rest of my life, this is still my trust. These are still my assets. Nobody is entitled to inheritance until I am gone. So, Section 4.01, first, take this property and use it for my benefit for the rest of my life while I'm incapacitated. However, Section 4.02, first, if I'm married still, if we are married still, make sure the trust is being used for both of us because maybe both of us now have become incapacitated and we need to ensure the trust property is applied for us. Additionally, we might have people that are still legally dependent on us. Maybe there's some minor children, or maybe I'm taking care of an adult disabled child. So the trust also can continue being used for their benefit, even while I'm alive. And finally, 4.03, this is just providing a little bit of guidance in how we go about satisfying these distributions in sections 4.01 and 4.02 that I just referenced. Now, when I pass away, or once we have passed away, there are some very basic wrapping up of our affairs that has to be completed. We need to make sure that our affairs are finalized before we move inheritance to the next place. So, section 5.01 first, if one of us has passed away, there's going to be some rules about how we leave things to each other. It's important because number one, we have some of those considerations about things like the estate tax, which I've talked about before. We each can leave a free amount of money before we pass. We can leave an unlimited amount of money to each other, but we need to be mindful of how we leave these assets to each other, partly for taxes. And then also because, as I mentioned earlier, maybe there are special types of property coming in here. Maybe there is community property, which is treated in a certain way. Maybe I had that separate inheritance from my family that if I pass away, I'm directing to go in a specific way to a specific person. So certain types of property are going to be essentially accounted for, and they're going to be managed and held a little bit differently than the joint property that we have together. So section 5.01 is just breaking all of these little pieces out. Payment of expenses and taxes. When I pass away, when we have passed away, we have to just resolve any final bills. So as an example, make sure that you have filed and paid my last taxes. Make sure that you have taken care of my cremation expenses, etc. So this is just providing expenses that need to be covered by the trustee first, again, before we move inheritance on to the next place. Excluding life insurance from creditors. So one of the benefits of life insurance is that under our laws, it can never be attached to or collected against in order to pay outstanding debts that we have when we die. So this is just reiterating our law that says if any life insurance comes into this trust, you cannot use it to take care of any bills or anything that I've left behind. Payment of death taxes and authority to elect portability. These are very specifically dealing with those estate tax issues that can come up. Now, as a reminder, it is highly unlikely that most people will ever be at risk of estate taxes. Since 2011, the lowest amount of money that we can leave tax-free on the federal level is $5 million each, $10 million for a couple. Now, that does go up and down over time, but it hasn't been less than $10 million since 2011. So, number one, if for any reason I become at risk of estate taxes, how do we handle those? Essentially, how do we deal with identifying, calculating, and then paying those taxes? So that's what payment of death taxes is covering here. However, as I just mentioned, spouses, we can double the amount that we can leave behind. So authority to elect portability, this is something that also came out of a law that was passed in 2011. And it allows spouses to take each other's exemption and basically stack it on their own. So instead of me leaving $5 million when I've passed away. If my spouse has passed away first, I can actually file a special tax return and take their exemption and I can stack it on mine. So now I could leave $10 million behind tax-free. This is referencing that process. Now, there are rules and there are timeframes very important to me. So I always tell people, always make sure that you have a good accountant that you can talk to about these things if and when it comes up that you actually need to activate this. Now, after these sections, your trust may differ in certain ways. So the first thing is there will be a section usually called specific distributions and disposition of personal property and disposition of remaining property. And then there will be additional sections that are going to come after here. So in this particular article, we're usually going to be identifying a few things. First, as a married couple, we have a marital residence if we do own one. So we want to make sure it's crystal clear. If I have passed away, that you just get the house. It's yours. You can continue controlling it and using it and enjoying it, and you can dispose of it if you need to. The property will continue being owned by the trust. So we're not actually changing the title. We're just saying here, anything that is held for us as a primary residence, it's going to go for the benefit of the other of us. Additionally, if you have any pets that you leave behind, we're commonly going to identify what's the plan for those pets. Is there a particular person or organization that might take them? And if so, do we want to leave a gift of any money to go along with those pets? Pets cost money, and we want to make sure our pets are comfortable and taken care of. So a lot of times for pets, people will do a fixed dollar amount per pet. Maybe, for example, $1,000 per cat and $5,000 per dog, just as an example. Some people will structure an annual gift for the rest of the pet's life. We can do that. Other people are going to have more specialized animals. We might have horses or other livestock. And so your trust may actually contain a section called disposition of chattel, because chattel is a legal word that we use to describe essentially livestock. So make sure any pets, any chattel provisions for you, that we identify the best people or organizations and any particular plans for the finances. The final main topic for this article is going to concern our personal possessions, our personal property. So when we make a plan, we're going to be moving our assets into the trust. One of the things that we want to be providing as well are some guidelines and some instructions about what to do with all of our stuff. We are a culture of people that generally likes to accumulate a lot of possessions. The challenge with that is we know what's important personally. We also generally know what we would want to have happen with everything, but nobody else knows that. And so in doing planning, to help prevent a lot of time and effort and frustration from being basically wasted by our trustee, it's a really good idea for us to write down those instructions, those wishes, etc. So there is a document that we're going to supply you as part of this process called a personal property memorandum. It is a Microsoft Word file. It is basically a document full of blank lines. And within that document, you can identify an item or groups of items, and then how you would want them disposed of. So what I typically tell people is think about two main categories of all of your possessions. What is important? Number one, what are things that I want to make sure are held or distributed in a certain way, such as I have a family heirloom that I want to go to this family member. Or maybe I don't care what happens to the asset, but I have a $10,000 piece of artwork, and I just need people to identify that that artwork is valuable and then do something with it. Don't sell it at a garage sale, don't donate it. The second category, very simply, is everything else. I have done hundreds of estate plans, and I've never once had somebody come in desperate to plan for what happens with their DVDs or what happens with their blankets. We have a lot of possessions, and we want to make sure people don't agonize over what to do with it all. So on the non-important items category, I generally tell people group it together and then tell them what to do. My own personal memo, it's about a page and a half. And in that, I have line items like all of my furniture, sell it. All of my books, donate them to the library. All of my clothing, take it to this organization. So in your trust, the first one, distribution of personal property by memorandum, this is simply identifying if I have made this document, if I have made a memo, trustee, those are my instructions. Take those instructions, carry them out. Distribution of remaining property. In this context, we have things that we maybe didn't identify, or maybe we didn't make a memo to begin with. So, trustee, whatever's there that I haven't told you what to do with, I am giving you the power, I'm giving you the discretion to make those decisions for me. Now, in every trust where we're going to have a married couple, we have a concept of how we're going to leave things to each other. This could differ in your specific trust based on your specific plans. We typically have two types of ways that we leave things to each other. One is called a survivor's trust. This is the most common form that we're going to use. So it's highly likely this is going to be in your trust, but this is the easiest, most unencumbered way of us to leave property from me to you. It is, I'll show you the details in just a moment, but it basically provides that when I'm gone, everything will stay in this trust and you will just continue using it, managing it, enjoying it, etc. The other way that we can leave things to each other is through what's called a marital trust. A marital trust is going to be a bit more restrictive here. It's going to provide, essentially, here's what you do receive from me, but here are some rules that apply otherwise. Examples might be maybe we're a blended family and I'm going to leave some things to you, but I'm actually also going to leave some things down to the children. Or maybe I'm going to leave things to you, but you're going to have restrictions in what you can do with it. Maybe how much you can access, or maybe limiting your ability to dispose of property, or limiting your ability to make changes to how this trust works. In a survivor's trust, we're basically continuing the status quo. You still own the trust and can do whatever you want. In a marital trust, we're going to break that status quo a little bit based on what our intentions, what our goals are, as well as any specific rules we're trying to meet, such as about separate property and making sure that you don't have the ability to dispose of it outside of my wishes. So in a survivor's trust article, it's going to be fairly short and simple. Section 1, trustee of the survivor's trust is going to be you as the survivor. Obviously, this is going to be your money, your property. You continue managing it until you can't. Importantly, in a survivor's trust, whatever I'm leaving you, you continue having the power to change this trust. So when we have couples that come in and they might be a blended family, or there might be special rules that we're agreeing to about how everything is going to transpire, we may not want each other to be able to just change anything after we're gone. So this is something important to discuss. Survivor's trust as the only trust. So the basic idea here is we don't have to set up a separate, different trust to hold everything that you're receiving. We're just going to keep everything under this one trust umbrella. When we use marital trust and all of that, we might actually end up having a couple different subsidiary trusts operating in different ways. But in a survivor's trust, we're keeping things really simple. Distribution of income and principal. Essentially, for the rest of your life, survivor, you can do anything you want. You have access to all of the income. You have access to all of the principal and the assets. General power of appointment. So one of the things that comes up in a trust is there's a structure that exists called a power of appointment. And the basic idea behind it is you, as the person receiving inheritance, you have the ability to control what happens to that inheritance after you. This is pretty rarely given to anybody other than spouses. It is something that we can always discuss in the course of beneficiaries of your trust and heirs. The difficulty with power of appointments for anybody that's not a spouse is that it creates some limitations. It weakens the protections of a trust. So we typically don't want to give that out except to spouses. What this is saying here is spouse, you're going to have this power. You can make any changes again as you choose in the survivor's trust context. And then finally, administration following the survivor's death. Once we have both passed away, at that point, the trust is going to become irrevocable and it cannot be changed. And from there, the next trustee that steps in is going to follow it based on the instructions we have provided. In some trusts, we're going to have a section where we actually provide here what gifts do we want to leave other than to each other and to the main beneficiaries, the main heirs. So you might see this in a separate article like Article 8. You might see it in a prior article, such as where we had that section regarding the personal property. But in the course of gifts, we can take specific dollar amounts like $10,000, or we can take specific assets such as this rental property or this car, and we can distribute them somewhere other than where they would naturally go. So if you have a specific gift, it'll usually be called specific distribution or specific gift. You want to review that. You want to make sure it's accurate. And then if there are any additional instructions or guidelines about how you want that specific gift to play out, then we can identify that here in this trust. A section that you may see following a specific gift is simply providing, as there may be additional financial considerations for that gift, here is what we do with it. So an example could be if I give a gift of a house and that house has a mortgage on it, that mortgage is going to follow that house. It's going to follow that gift. And or if there are any costs associated with the gift, maybe to ship the gift to a person in another state, then the trust is going to take care of that. So you may see some additional language following your specific gift. Now, the most important section of a trust. This is going to typically be called our descendants trust or our beneficiaries trust, something along those lines. But this is going to provide as detailed a breakdown as you choose to create for how the inheritance that's left over is going to be held and divided and managed and distributed. There is going to be either very simple language in here or very complex language. There usually isn't much of an in-between. In the example I'm going to go through here, we're going to have a lot of different provisions built out. Now, your trust is unique to you. You may have any number of additional provisions and rules and instructions here. Common examples are things like real estate. We may create something called a right of first refusal that says beneficiaries, if any of you want to buy each other out from our house and keep the house or turn it into a rental or whatever you want to do, there's a process, and here's how you go about doing that. Or we might literally add a section called trustee guidelines that's going to establish certain expectations, certain instructions to the trustee for how you're wanting them to make decisions and what to consider for your heirs. In most trusts, one of the first things we're going to have here is a rule about marriage. When our beneficiaries receive inheritance from us, it's intended to go to our beneficiaries. Most of the time, we are not intending for our children or grandchildren's spouses to gain any legal rights to the inheritance. So to prevent that from happening, one of the rules that we commonly impose is that the beneficiaries, in order to receive the benefits of this trust, they have to sign a marital agreement with their spouse, wherein the spouse is giving up any right, claim, or title that they would ever have to the inheritance. This does not affect any of their other assets, any other aspects of their life. It only applies to the trust. It only applies to this inheritance. And it's a fairly straightforward process. And to be honest, it's very painless, in large part because if they don't sign the trust, they don't get the money. If they don't sign the agreement, they don't get the money from the trust. If they do sign the agreement, they get to continue enjoying the inheritance for the rest of their lives. It's just making sure if they don't stay married forever, that we have a clean path so that the trust doesn't end up getting involved in a divorce. We often will include, especially for younger heirs, younger beneficiaries, a couple contingencies that are important to consider. So one is going to be about substance abuse. Our goal with creating inheritance, with creating this legacy, is we want that to be used for their benefit. We don't want that money to be used for them to hurt themselves. So should there be a substance abuse situation, either a historical problem or something that comes up in the future, we'd like to provide just a lot of additional guidance to our trustee with how they might respond to that situation. So take a look at that closely. And if there's anything else you'd like to say, or if there's anything that you're not comfortable with and would like to remove, you can absolutely do that. The other essentially rule or guideline that we're going to build in, again, usually for younger beneficiaries, is going to be something called gainful employment. And the way that I describe this to clients very simply is this is not a golden ticket. If I am gone, this trust is for you, but you have to continue doing something with your life. So this is providing a number of things that if you're going to receive inheritance, you have to meet one of these many different requirements in order to continue benefiting from it. Now, if you have children that are under the age of 18, you may well have a section in here called a common trust. A common trust is it's a concept that we use with young children because while they're minor children, we need to make sure that each child has access to 100% of the inheritance. They're going to have differing needs for school bills and medical bills and living expenses and all of that. And we don't want one child essentially being penalized later, getting less inheritance as an adult because they had more needs as a child. So a common trust, there's going to be several sections of this, but a common trust is going to say, while any of the kids are still underage, while any of them are still a minor, we're going to pool all of the inheritance together and they're all going to have 100% access to it. And then once they become adults, all of them, whatever's left in that pool at that point, it's going to be chopped up into equal parts for each child. And then as adults, they're then going to address and draw from their own specific inheritance. So these sections in the common trust are just providing some rules about how the distributions are made and that it's going to terminate once they're all adults. And then in any trust, regardless of whether you have a common trust, we're also going to provide in here, how are we going to actually divide whatever's left in inheritance? In most trusts, people are leaving things to children and grandchildren and the like. So we're going to say something along the lines of, we're going to create shares for all of our descendants. Descendants are identified, defined back in Article 2 in that family information. Other people may not have children or grandchildren, or maybe they want to leave things to their kids, but also some other family members or friends. That's all fine. A different way that we might structure this section is actually identifying individual beneficiaries and the percentages that we're giving to each of those beneficiaries. Regardless of how we set this up, number one, a separate share, basically like a separate account, is going to be set up for each beneficiary and funded with their percentage of the assets and the income, by the way. And then two is the most common way that we're going to set up a trust is through a structure that you're going to see here called by representation. It is defined further in the definitions section, but by representation, it is the English version of a prior Latin term that attorneys used to use called per stirpes. And so what it basically means is when I leave something for you, it's then going to go down your family line if you happen to pass away. So if I leave something to a child and that child is growing up and eventually they have kids of their own and my child passes away, whatever might be left in this trust for them is actually going to drop down then to my grandchildren. and they'll get an equal amount of whatever their parent left behind. In other situations, we might leave something to someone, but then say it's not going to pass by representation for them. So we'll usually define that in here, usually in the administration of trusts section below. But we might say something along the lines of, I'm going to leave this to you, let's say Susie. But Susie, if you pass away, then I'm actually going to take whatever's left and direct it somewhere other than to your family members. Now, in administration of the trust, again, we're typically going to have some standard sections, but there could be some things that are unique to you. So distributions of income and principal as an example. When this all gets set up for the beneficiary, for the heir, essentially, how are decisions going to be made about when they receive income from the trust or when they receive any principal out of the trust? We might keep things somewhat conservative, the way that this trust example is written, and say that the trustee gets to decide those things. Or we might start spelling out very specific rules, such as at this particular age, you get this percentage, or at this particular age, you actually get to become the trustee of the trust and take it over and manage it. As an example, in this section that's highlighted here, annual right of withdrawal, we can build out language that says starting at a certain age, you get to take a certain percentage of your trust every single year. That creates consistency and it allows for a lot easier of management by the trustee because they know that every year they're giving a percentage to the beneficiary. In termination, we're always going to have a standard section here that basically identifies under what circumstances does the share for any given beneficiary end. Example, we've used all the money. Or we're all in agreement now, the trustees and the beneficiary, that it's just time. It's time for this to end for them and to be distributed out. And then finally, of course, when a beneficiary passes away, their particular share will end, but then it's going to move on to the next place, such as in this subsection D here, distribution upon the death of. This is saying that that share would go to the beneficiary's descendants. Or again, we might write it differently and say that it goes to the other beneficiaries that are named here. Or I could say that it just goes somewhere else completely. Now, that article that I just showed you is the most important article of the entire trust. Immediately following it, there's going to be an article called Remote Contingent Distribution, and it's going to be structured in one of two ways. This way here is the default. It's what a lot of people will use, but not everybody. And the default here is basically saying it's possible that every single beneficiary and backup beneficiary could be gone. And in that situation, if there's something left in this trust, then here's how we're going to locate the next beneficiaries. So in the default, for example, we're going to take everything that's left and we're going to cut it in half. And 50% is going to go to each of your families, each of your next of kin, which is determined by our state statutes. Now, for a lot of reasons, this doesn't work for people. And so the other way that we might set this up is we might actually identify the backup beneficiaries in the trust. Common examples, I get a lot of clients that there may be a young family, a couple of parents, maybe a couple of children, and that's it. There's no grandchildren, there's nobody past them. So they might say, well, if we're all gone, we want to leave money instead to a charity, or we might want to divide it between, this sibling and this friend and this cousin, etc. So in remote contingent, there might be a section that actually identifies beneficiaries and percentages. So just make sure that that information is accurate or provide us that information if it's still missing. In Article 11 of this trust, you're going to see a lengthy article called Distributions to Underage and Incapacitated Beneficiaries. Now, in the whole estate plan, this is the one article, the one primary section I will encourage you not to read. The language is very important. It's very valuable to have, but it's highly technical. There are different situations that can happen with our future beneficiaries. The most complicated of those is that the beneficiary at any time, they might find themselves after an accident or maybe a medical issue or something like that. being disabled or what we might consider special needs. In that situation, they may then look to qualifying for important benefits such as Medicaid or Social Security Disability or something called SSI. These are what we call needs-based programs. And by needs-based, it means the person who's applying, they have to demonstrate a certain financial need for it. And the problem that we have is if you leave them inheritance through this trust, it's going to cause them to be disqualified from those benefits. That's going to cause a lot more harm than good here. So one of the solutions that we have available is something called a special needs trust. It's a way that we can take a beneficiary's portion of the inheritance and retool it, restructure it in a way that they can then simultaneously receive the inheritance, but also receive their benefits. Special needs trusts work fantastic. They're used all the time. It's just that the language is very technical and very dense. So I will encourage you not to read it. If you do, this will just give you some context. There's a lot of legal rules that dictate how special needs trusts work, so we cannot change this language, but it's there if needed. If it's never needed, then we don't have to worry about it. Similarly, for 1102, when we have beneficiaries that are considered underage and or incapacitated themselves, how does our trustee do this? How do they deal with this? And then in the very next section, how would they then make distributions out of the trust to those people? Well, it's probably not going to go to those people. It's probably going to go to their guardian or their parent, or maybe we set up certain structures that allow us to leave things to a person who's underage, such as what's called a Uniform Transfer to Minors Act account. So again, should these situations arise, we have covered them. If they don't ever come up, though, we're not going to use these sections. And then lastly is retention in trust. So the basic idea here is if we end up having to hold things for the benefit of a person that is underage or incapacitated or anything like that, what's basically the process for how we distribute income or principal, how we make those decisions, and what's their ability to withdraw money that's accumulated in that trust up until the point they become an adult, what happens when they pass away, etc. So this is only applying to these very specific situations. And the language here, just to be really clear about it, it's actually dictating as certain distributions have to be made to a person who is underage or incapacitated, then these rules are going to apply. So like an example is when we have a child that is a minor, but we maybe have an annuity that's paying out, or a fixed payment structure that's coming out from something. How do we hold that property and manage it for them until they're ready to receive it? Now, after this article, we're going to have a lengthy section called Trust Administration. This is very simple and straightforward. It's just providing some standard processes, some standard rules about how we do this. So the first one that we'll have highlighted is no court supervision. And the very simple explanation here is the whole purpose of doing this plan is to keep it out of probate. So, trustee, as you are administering and managing this trust, you are not required to have a judge oversee it. Distributions to beneficiaries. So the basic idea here is just saying the trustee, when they distribute money out to the beneficiary, they can distribute it. They have no obligation, the trustee, to follow up and find out what the money was used for. That's just overly cumbersome and micromanaging, and it will be very difficult to enforce. Beneficiary status. Very simply, it's the trustee. They're going to operate on the status quo until they're told otherwise. So an example is if a beneficiary is single, the trustee is just going to keep operating as though they're single until the beneficiary notifies them that they got married. Things along those lines. Majority control. If we ever have two trustees serving together, co-trustees, then they're always going to make decisions for the trust by a majority vote. Obviously, if there's only two trustees, they have to agree on things unanimously. But if there were three trustees, then two out of the three get to make decisions. Delegation of authority. What I always tell people here is trustees are not required to do or know everything. So during the course of administering the trustee has the ability to delegate powers and responsibilities to somebody else. This is common when we have trustees that just don't have experience, maybe managing certain assets, or maybe, we have people that are taking care of the kids and they should be making certain decisions for the children while the trustee is managing all of the investments and the more complicated components of it. Trustee exoneration. We have a line of trustees that are potentially going to serve. It's just important that if a trustee steps in, they don't become responsible or liable for any bad decisions that were maybe made by a prior trustee. It's rare that we come up against issues of bad decisions anyways, but if we do, we want to make sure that nobody else becomes responsible for somebody else's decisions. And then trustee compensation. This is a very short section, but it leads into a much larger issue. Trustees fall under a category of people that are called fiduciaries. As fiduciaries, they are allowed by law to ask for compensation for the time and effort that they spend carrying out this trust. So number one, it is optional. Trustees do not have to take compensation. And I find that most of the time when trustees are family members or close friends, they don't take compensation. The other component of that is compensation is fairly heavily regulated, the process by statutes. So if a trustee is going to step in, there are a lot of rules and responsibilities and checks and balances. And so we find that a lot of trustees generally don't even want to deal with that. And that's why they also don't take compensation. But if a trustee is serving, if they are expending time and effort, and if they do want to be compensated, then this is going to give them the opportunity. And from there, they're usually going to work with somebody like an attorney or an accountant to determine what they can do and how they get compensated. As I had mentioned earlier, there is that concept of the power of appointment. Now, I generally recommend that clients don't provide powers of appointment to their heirs and beneficiaries, but you saw that there was a power of appointment that was given in that survivor's trust section. So in essentially every trust, we're going to say, should there ever be a right to the power of appointment? Here's how you exercise it. Again, most of the time, this is never going to be an issue, but we need to define how people can use it if we ever decided to give that power. And then determination of principal and income. This is a fairly short section referencing a fairly large statute. Questions might come up during the trust administration process by the trustee of things like, well, how do we qualify this money coming in? Is it principal, in which case we can maybe try to lower tax obligations, or is it income that we're going to have to calculate and then figure out what to do for tax purposes? There is a law called the Uniform Principal and Income Act that provides great levels of detail and instruction about this. So this is just referencing that law if the trustee ever has a question about how to make these decisions. Authority to terminate trust. So when the trustee is carrying out this trust, we might get to a point that it just doesn't make any sense to continue the trust any longer. An example might be if there's only $5,000 left in this trust, the time and the effort and maybe some costs associated with managing it, it doesn't make any sense. It's no longer worth it. So there are circumstances that the trustee might terminate a trust. This is giving them the ability to do that. Reports, also called trustee accounting. This is a very important section. As I had mentioned, trustees fall into that category of being a fiduciary. Fiduciaries have a number of duties, and one of the most important duties is that they have to be transparent with how they are carrying out this trust. So in this, there are a number of rules here, but the basic idea is that trustees have to keep immaculate records. Records of assets and debts, records of income and expenses, records of taxes and compensation and all of that. And then they have to make those records available to the beneficiaries. So this is detailing for them those specific rules. You, as the creators and owners of the trust, you have no obligation to do this while either of you are trustee. This only applies to the trustees after you. There's going to be a lengthy section regarding all of the powers that a trustee has to carry out this trust. This is going to be pretty similar in scope to that general durable, that financial power of attorney that we went through, because we need to make sure the trustee can manage every conceivable asset or issue that might come up in this trust. There are pieces here that likely won't apply to you and may never apply to you. There are pieces here that are going to be obvious and pieces that won't be obvious. So I do recommend first that people actually start with the table of contents. Take a look, and then you're welcome to turn to any of these. Most of them are going to be about a couple paragraphs. So I'll give you a little bit of a snapshot of each of these. Introduction is obviously just an introduction, so please feel free to read that. Execution of documents. So your trustee can sign whatever documents are necessary in order to facilitate managing the assets, making decisions, etc. Investment powers in general. Your trustee actually has a fiduciary duty to invest your money. They have obligations to try and grow the money that's in here. So this is a little bit of a guideline, I should say, for what they're going to do in terms of taking over those investments. Banking powers, very simply, your trustee can manage your checking accounts, your savings accounts, your certificates of deposit that may end up in this trust. Business powers, there's going to be a little bit more detailed language here. But if you happen to own a business or even like a minority share in a business, your trustee then can step into that role and they have the power to manage your business ownership interests, including some of these very specific subsections. Contract powers, your trustee can sign contracts. Your trustee can reach any forms of agreements necessary for administering the trust, buying assets, selling assets, etc. Digital assets. So we have a number of things that would fall under the category of a digital asset. Everything from our basic email accounts to social media platforms to websites we own to any number of things that would essentially be software related. So this is ensuring that our trustee has the power to step into those, take possession of them, secure them, and manage or dispose of them. Farm, ranch, and other agricultural powers. So to the extent we do have any agricultural interests that might go into the trust, this is giving our trustee the power to manage those, including such things as allowing for contracting to farm the actual land. Insurance powers a little bit lengthier, but we want to make sure that our trustee has power over all insurance policies we have, as well as the ability to obtain additional insurance for us, everything from homeowners insurance, disability insurance, etc. Loans and borrowing powers. So this is one that we commonly get a question about. There's two components here. The first is the trustee's ability to take out a loan on our name, on our credits. And the other then is the ability of the trustee to allow people to borrow money from us, for us to loan money to other people. So we generally want to make sure the trustee has the power to do some of this. Right now, I want you to take a look at the language that's in your trust, and you can identify if you want to restrict that in some way. But I usually get a question of, why would we want a trustee to be able to take out a loan? Well, an example, let's say that you need an expensive piece of medical equipment, but we don't want to deplete your checking account or have to liquidate investments in order to make that purchase. It might make more sense for us to take that money, to take that purchase out on credit on a loan. So our trustees should be able to do that. As an alternative, some people might restrict their trust in a way that says, trustee, you can't take out new loans, but you obviously can manage all the existing loans and debts that I have. The same side on this borrowing idea. So I have families that will come in and parents may routinely loan money to their kids and then their kids pay it back to them. So when we have situations like that, we might want the trustee to be able to continue doing that. Again, in other situations, people might modify this language to take that out, and that's okay. This is your trust. You have control over the powers that you give. Nominee powers, this is a fairly specific and kind of attenuated issue. There are assets that exist where legally the asset actually has to be placed in the trustee's name rather than in the trust name as a whole. It's a distinction, but kind of an important one. An example is, I believe it's Nebraska. Nebraska actually requires that real estate has to be held in the name of the trustee rather than the trust. So if I owned property in Nebraska, it would have to be titled Brandon Campbell trustee rather than, the Campbell Living Trust. So this is just providing the trustee can do that if it's required of them to do that. Oil, gas, and mineral interests. It's pretty rare that we see these, but if you happen to have any mineral interests, we need to make sure that our trustee can manage them. And we want to leave this language even if you don't have these interests, because it's technically possible you could acquire them in the future. Payment of property taxes and expenses, fairly straightforward, but obviously your trustee can pay your property taxes. Qualified property valuation. This is just providing basically if we have to go through a process of valuing real estate, what we call real property, trustee, you have the power to do that, including under a specific section of the IRS code. Qualified tuition programs refers to what we call those 529 accounts. So a 529 account is an account that's set up for the benefit of a minor child. The account is actually owned by the child. People don't usually understand that. But you, as the parent, or maybe another relative, are installed as the custodian to manage that account while they're still a minor. So there's very specific language that needs to be in a trust in order for it to be able to become custodian of a 529 account. So we always include that language in here to make sure that your trust would qualify if needed. Real estate powers, somewhat self-explanatory, but our trustee can manage every aspect of real estate that we may own. Residences and tangible personal property. So there's a couple of things here. Number one, the beneficiaries that we're leaving things to, our trust can actually take the money from their inheritance and use it to purchase them a home. And then second is the tangible personal property that we have. It's going to come into the trust. And there's going to be a couple notes about here, like for example, if I have some personal property that produces income, maybe I own some vehicles that I rent out as an example, and those produce income. Retention and abandonment. Basically, the trustee is going to hold the trust property, but they have the ability to dispose of property if needed. And they technically can actually convert property as well. If I have something that's not producing income, let's say I have a rental property that's not doing well, my trustee could actually sell that property, buy a different property in order to then start producing income from it. Securities, brokerage, and margin powers. These are just specifically to the different types of investments that we might have, giving our trustee full power to be able to manage, acquire, and liquidate investments. Settlement powers, very simply, a trustee can settle any claims, any issues that come up inside of the trust on behalf of the trust. And then finally, limitation of powers. A question that we get a lot is, what is this difference between what I'm seeing an independent trustee versus an interested trustee? An independent trustee is somebody that comes in to manage this trust who does not have any inheritance or other interests coming out of it. So maybe I am going to have my best friend be my trustee, but everything I have is going to go to my kids, grandchildren, etc. Well, my best friend, they're never going to receive anything from this trust. So they're considered independent because they don't have any particular conflicts of interest in how the trust is going to be managed. On the other side of that, we have interested trustees. That is somebody who is going to inherit from me. When somebody's going to inherit from me, it creates a conflict of interest, and it could put them in a position where they might try to manage the trust in a way that benefits them more than other people. So there's some limitations that are built in here. If somebody is an interested trustee in how they are allowed to make decisions to make sure that we minimize that conflict of interest as much as possible. But an independent trustee has the full unrestricted power to manage the trust as needed because that conflict doesn't exist. At the end, we're going to have some general provisions. So the first one you're going to see, maximum term for trusts. As I've probably described to you, trust can last a very, very long time. Every state has their own rule. This is called a rule against perpetuities, by the way. Colorado, a trust, once it becomes irrevocable, meaning once we've both passed away, the trust can then proceed for 90 years. Now, nobody usually ever comes close to that point, but you might need a trust for 20 years or 40 years or 60 years. So this is just referencing for your trustee how long a trust can go. Spendthrift is a very, very important section. So spendthrift is creditor protection. The idea behind it is nobody can come into my trust to try and collect or attach to any of my beneficiaries for their debts. So if I'm leaving money and property to my child, and let's say they're driving their car and they get into an accident and they get sued, well, they might lose their house and their bank accounts and their car. But when we pass away having the trust, we actually continue owning it, which is kind of a strange idea. But it creates this benefit called spendthrifts. And the very simple way of thinking about it is nobody can come after my money to pay somebody else's debt. So when we're gone, this trust is going to create a very strong bubble around the inheritance to prevent outsiders from being able to get at it. Now, there's obviously some exceptions. You can never really get away from like the IRS, but for the most part, anybody other than these really big ideas and agencies, nobody can touch the funds. You're going to see a section called contest. This is an incredibly important provision. When we have a trust, when we have any estate planning, we need to make sure that nobody can fight. Fighting in the context of probate and estates and all of that, it is incredibly complicated. It's incredibly frustrating. It's incredibly expensive. So in contest, we are actually providing a penalty. You are going to inherit from me, but you are not allowed to uh, fight or sue. You're not allowed to try and overturn my wishes. You're not allowed to do 1, 2, 3, 4, 5. So in this, contest is saying you're going to inherit, but if you take any of these actions that are listed, you are going to activate this provision. You will be kicked out of the trust. You will lose every penny. Anything besides this is fine. If beneficiaries or trustees or anybody are fighting and disagreeing, in general, that's not a problem. It's once we get to the point that somebody tries to sue. And there's actually some language in here that allows them to take other paths to resolving their issues, such as mediation. Contest is authorized by state law, and I have found over my career that it works 100% of the time. If people find out that they're about to get disinherited from what they're going to do, they're going to stop. They're going to come to the table, they're going to sit down, and they're going to figure out a solution because they don't want to lose everything fighting over a little bit. After this, there's a couple of technical provisions. So survivorship, there is an idea that we need to make sure if I pass away and then subsequently you, my spouse, or maybe the beneficiaries pass away shortly after me, we don't want to have to go through the process of moving all the inheritance from me to you, and then a couple weeks later now having to move it from you to the next place in line. So we build in a window of time that says you have to survive me by at least 30 days. And that way, basically what we're covering here is, let's say we're both in a bad car accident. If I pass away now, and there's a very strong possibility you might pass away in a week or a couple of weeks, we're building out enough of a window to address that and basically make the trustee's life a lot easier, not having to administer the trust multiple times in a short window. For married couples, we need to identify the fact that we might not always be married. So there's going to be a section that's called effective legal separation or dissolution of marriage. And what it's saying here is if we do start a process to get divorced or separate, then essentially here's how we're going to treat this trust. Here's what we're going to do with it in response. And you're generally going to want to talk to us. You're going to generally want to talk to some family law attorneys if and when that did happen, so we can better advise you about what next steps are going to be. Below here, once the trust is actually being carried out, please understand your trustee doesn't have to administer it in Colorado. They don't have to come here. They could move the trust to another state. For example, maybe it's because that's where they live. Maybe that's because that's where you live at the time. That can happen. But we just need to make sure the trustee can effectively move the trust from here to somewhere else if needed. And then there is a lengthy definition section at the end. I want you to review it, reference it as you need. There are many, many definitions here for you. And then finally, there are a couple what we call rules of construction, which are, it's a contract term, essentially for how we read this document. One of the important ones is the very beginning, which says, we're going to sign this trust, but a copy of this trust is just as effective as the original signed version. So as needed, you can print copies, you can email copies, etc. Additionally, you're signing this trust under the laws of Colorado, making it valid, but you can move in the future and you can move this trust. Or like I just mentioned, trustees can also move it to another jurisdiction. Finally, something you might see at the very end of your trust, you might not, it depends on your planning, are going to be what we call these schedules. And these schedules are if you have any of those specific types of assets I mentioned towards the beginning, such as separate inheritance I've received from my family, or maybe we do have a property in one of those community property states. It's important that we itemize those here because we need to have a record with the trust that's going to provide what's mine is mine, what's yours is yours, and what's community is community. Otherwise, we're going to default that what we put into the trust, we're going to be treating as joint marital property. So I will reinforce to you, if you have something that you want to identify as your sole and separate property before we put it in this trust, you need to tell us that, and then we'll take that information and we'll put it in a schedule for you. Your trust is long and it is dense, but as easily as I can say this, it is fairly straightforward. I recommend that you take time to review this. You do not have to review it all at once. You can maybe break it up over a couple of days. And as you go through, I want you to keep referencing back to this video as needed to help you with understanding the various sections. Again, your individual trust may have different pieces that you didn't see in this video, and that is okay. If there's something that's in yours that is not in this video, you're welcome to reach out if you want any more clarification about what those sections say or building out additional language. Otherwise, keep us posted as you continue the review, and hopefully this video is going to put you in a much better position to understanding what you're dealing with here.